Mr. Hughes does not want to do DNA testing. I believe he is confident that the child is his.
I didn't say it. I didn't say she was my child. Yeah, I know I'm not, because I'm married, so I know I'm not.
If she's just naming you just because she wants to, hopefully she'll show up to get you out of the way. I don't know. Take notice of Miss Gibson was served October 7th, 2023. Ms. Phillip, go ahead.
Yes, Your Honor. I do have a question for you on this case as far as how to proceed. The mother is not present today. We filed a petition to establish the parent-child relationship, and so no DNA testing has been done yet to prove that Mr. Hughes is the father, and the mother's not present to testify as to whether or not he is the father and whether or not she was married at the time that the child was born. Mr. Hughes does not want to do DNA testing. I believe he is confident that the child is his. So he's not asking for DNA testing, I believe, but I will take some testimony from him regarding that. But the state's position was that we should probably get DNA testing before we can establish him as the father.
Mr. Hughes, let me have just a quick discussion with you about the DNA testing. So I understand the mother's not here and you may want to get your case done today, and that's fine with me. I don't mind getting your case finalized today, but we don't have the mother here to testify affirmatively that you're the father. Obviously, she named you with the Attorney General's office, and you may not have any doubt. And we can definitely do a court order that puts you on child support and all the rest of everything else we need to do. But at some point in the future, if she tells you that you might not be the father, or you do DNA test after we're done with court today, and they show that you're not the father, you're going to be on the hook for child support till the child becomes an adult.
This hearing starts with confusion already in the air. The mother is missing, and that absence changes everything. No DNA test means no clear truth, yet the court is stuck working with assumptions. Mr. Hughes thinks silence equals safety. The state wants proof, not confidence. Paternity is not about belief, it is about evidence on record. The judge sees a problem forming early. Without the mother, facts are limited. Without DNA, risk becomes permanent. This is where decisions turn dangerous. Everyone wants closure today, but shortcuts create lifelong consequences.
I'm not going to be able to undo the court order. I don't know how much, if that helps you to consider that, but obviously we do order DNA testing. Mom still has to appear. But I want to make sure that at least that you understand what your rights are, because I don't want you to complain to me later on, a few years from now, that, hey, I'm not the dad. What happens? I can't do anything to help you at that point. Nobody can. You'll be stuck. So do you want to go forward today, Mr. Hughes, or do you want us to reset it?
No, I didn't say it. I didn't say she was my child. I didn't say that. I just said I wasn't doing no DNA test.
Okay. So you just
I didn't say she was my child. They told me do a DNA test, and I said, why would I do a DNA test if she's not showing up for court? That means she's not gonna show up for DNA test. That's what I told her.
Oh, okay. Well, that's a little different. Okay, so do you have some doubt whether you're the father or not?
Well, I wasn't with her, sir. So it was about like what 9-10 years ago. I messed around with her a couple times, and that was it.
Okay, so yeah, there's a reasonable that you probably might not be the father too, right?
Yeah, I know I'm not, because I'm married, so I know I'm not.
Well, just because you're married doesn't mean you're not a dad somewhere else.
Well, I know I'm not. If I was the dad, it'd still be in court, sir.
I don't know. Well, for some reason, she picked you. The only way we can eliminate you is by doing DNA testing. So let's go ahead and order DNA testing then. And you do your
But
part.
I'm saying, how y'all gonna do a DNA test and y'all can't never get in touch with her now? This our third time coming to court.
Well, you're gonna have to get her to. We're gonna have to get her to come, because otherwise, you're gonna be coming to court for the next several years doing the same thing you're doing today. And I'm sure you don't want to do that, do you?
But I'm saying, if she taking me saying I'm the dad, right? And then I'm not having no idea. I'm just getting popped with a question. Hey, you got to go to court. I come to court. She not showing no court. Then y'all just telling me, oh, we're gonna make you
The judge slows everything down for a warning once a court order is signed. It never disappears. Child support is not reversible. Mr. Hughes tries to back away verbally. He insists he never claimed the child, but refusing DNA sends mixed signals. Marriage is used as a shield. The court quickly removes that illusion. Time as past memories are weak. Doubt is now officially admitted. That doubt changes the direction of the case. Confidence collapses under questioning. The judge stays patient, but firm. Reality replaces assumptions fast.
Deal with this child. We're gonna make you do this. Then, come on, man. How that? That ain't right.
You didn't answer my question.
What's the question?
You understand that if we just reset your case, we're going to be doing this, the same thing we're doing today, the same discussion we're having today. We're going to be doing that for the next several years. The only way to eliminate that from happening is for us to get DNA
Well, y'all have to do that
finished.
for the next 30 years.
Excuse me, sir.
I don't feel comfortable.
I don't like when people interrupt me. I don't like when people interrupt me. I listen to you. I let you rant and rave. I understand what you're saying. But there's only one way to fix this, and it's to get DNA test results to say you're not the father, so then we can dismiss your case, and no matter what she says after the results come in, we're never going to bring you back to court. If we don't do that, then you're going to be in court over and over and over and over again. That's the only there's only two options. And I'm sure you don't want to do that, so that there's nothing I can do except that. I'm trying to help save your time, and I understand it may be frustrating, but that's what we got to do. All right, so to order DNA testing, Ms. Phillip, what reset date?
We're asking to reset to February 29th, 2024 at 9 a.m.
All right, the Attorney General's office is going to send you information about where to go to your part of the testing. You don't have to go with the mother. Just do your part. They'll at least will note that she was there. They're going to reach out again to the mother to get her to do the testing. If she's just naming you just because she wants to, hopefully she'll show up to get you out of the way. I don't know. But we'll keep trying here. And as soon as she shows up, then we can move forward. All right. You're done with court, Mr. Hughes. You can press leave on the Zoom to exit out. Thank you.
They only required him to pay $4, and that's not enough to even help her with anything.
You're Gloria Nagel?
Yes, I am.
All right, man, this is your motion, your objection to a child support recommendation, is that correct?
Yes.
What is your objection, ma'am?
Frustration spills out from Mr. Hughes. He feels targeted without proof. Repeated court dates feel like punishment. The judge explains the cycle clearly. No DNA means endless hearings. One test ends everything permanently. Interrupting the judge makes things worse. Authority is asserted immediately. The courtroom demands order and logic. Emotion does not solve legal loops. The solution is simple but uncomfortable. Test now or return forever. The court chooses efficiency over argument. DNA testing becomes unavoidable.
Okay, Kevin has had visitation rights with Abigail. He has chose not to visit with her. What my objection is that I kind of need help with her. She's a special needs child a little bit. She goes to Irisa. She cannot talk. She's in a 1st and 2nd grade level in her mind. I just need a little bit more help with her with the money situation. I can't do it all on my own. And they only required him to pay $4, and that's not enough to even help her with anything.
All right, thank you. Friend of the court, as to the calculation on this matter, anything that you'd like to say?
The defendant is on SSI only. He is not able to make any outside income from that.
Right. And that was verified that he's receiving SSI?
Yes, received a letter from Social Security.
Thank you. Mr. Lefebvre, is that correct that you are receiving SSI benefits?
Yes, Your Honor.
Are you performing any work at all at this time?
No, sir.
Does the child receive any money based on your SSI or not?
To my knowledge, no. That one I'm not 100% sure on, though.
Ms. Nagel, do you know if there's any money that the child receives?
She was receiving money at $73 in Indiana when we were down there. But when I moved up here, it all changed. So I don't know where they took it out from, but yeah, he was paying child support. He was doing good.
All right. Well, I think the party should look at to see whether or not there's any benefits that could go to the child based on dad receiving benefits. The child support manual indicates that SSI is not treated as income. So that's why the support was set the way it was. Based on the arguments, I don't believe there's any errors in the calculation. So I am going to deny the objection to the child support recommendation.
Okay.
And you do have 21 days to object to my decision. That information will be provided in the paperwork that is sent to you.
Alrighty, thank you.
both.
The tone shifts as a new case begins. A mother speaks from exhaustion, not anger. Special needs change the weight of support. $4 feels symbolic, not helpful. The system explains its limitations. SSI cannot be treated as income. Rules restrict even sympathetic outcomes. The judge acknowledges the struggle openly. Law does not always feel fair, but calculation errors must exist to change orders. Possible benefits become the only path forward. The objection is denied by statute. Appeal rights are clearly explained. The courtroom closes with reality, not relief.